course, in cases filed against you, you don't merely avoid conviction. Of course, there are some things that you would also have to consider. First, the time. Second is the investment. Third is the opportunity. Fourth is your peace of mind. And fifth is your personal wealth. So out of the 100 targeted accounts, hackers were able to reset 45 user accounts' passwords. Now, these hackers
be very fast in saying, yes, I want to go fishing with you, because this person might be talking about a different kind of fishing, a fishing that will lead to a criminal offense and probably put you in prison.
Does not fall under the Data Privacy Act if it is an information pertaining to an entity that is not a natural person. Consent must be something that is mechanical and tangible. It must be proven. That is consent that is required under the Data Privacy Act. You have to prove that you have obtained the consent from a data subject. Who may wish to have some questions, probably they can send their questions to the Villasis Law Center and we'll try to answer them.
No? We were reminded by the National Privacy Commission that the cardinal rule, if you talk about processing of data information, is that do not collect if you cannot protect. protected. The primary impact of the Data Privacy Act, my friends, are the 8 rights provided by law. Very important. There are 8 rights here. You talk about the right to be informed, the right to access, the right to erasure or blocking, the right to object, the right to rectify. You talk about data portability, the right to file a complaint, and of course, the right to damages. Data is more valuable than money. Because if someone takes your money, that's all they have. Okay? But if you let someone take your data, oh my God, eventually, they will take your money too.
So does the DPA only cover personal information per se? Or does it also cover information about companies, testing results, and...
Hey sir, good
Hi.
evening. Sir, just a question about the DPO officer. Is there such a thing as a void or not valid DPO officer appointment, wherein even though the NPC has properly recognized his appointment?
We will be having our second quiz.
Just kindly, enter the link in the chat box, okay? So we can get started. So I think a little bit of an icebreaker is in order. Can we bring out the wheel?
Yes, we will do again a raffle. Congratulations! Ronaldin A. Urban.
On civil procedure. Okay, diretso. Yung 2020 rules on civil procedure were promulgated by the Supreme Court precisely, my friends, because of the Supreme Court's rule-making power or the power of promulgation, actually. So let me begin, my friends, no? So, if you will read the amendments, actually, if you will study it carefully, you will realize that there are how many areas here? Only 9 areas to consider, okay? What are these? Amendments under the rules on pleadings. Pagkasama-samahin ko na. Rule 6, 7, 8, 10, 11, and 13. The number 2, amendments, no? Under Rule 10 on amendments. Okay? Important changes introduced to the rules of amendment under Rule 10. What else? Amendments under the rules on summons, Rule 14. Okay? What else? Amendments under Rule 15 on motions. Amendments, of course, introduced to Rule 18, pre-trial. Dito, marami po. Ayan. And of course, Rule 30, trial, my friends. Finally, there are amendments also that should be discussed under Rule 33, my friends. Okay, under Rule 33, divorce of evidence, and of course, judgment on the pleadings under Rule 34 po yan, Rule 34. Okay, and of course, summary judgment, Rule 35. So let us enjoy our journey towards the rules on civil procedure. Notable changes in amendment under pleadings. If you talk about the rule on verification, di ba? Yung verification po, yung attestations niya, expanded na. Bakit? Okay? I'll start, my friends, no? By first, ito. Di ba yung sa verification, who must sign the verification? General rule, the party must sign the verification. Certification is from shopping, the party must sign. The certification is from shopping. That is the rule. Okay? Pero paano if the party is an individual? Okay? And he executed a special power of attorney, SPA, authorizing another individual to sign the verification. Is not allowed. Di ba? What if
Good day, VLC Warriors! Please visit and subscribe to Villasis Law Center YouTube channel. Together, we can make things happen. Together, we can.
The law firm of Villasis and Partners, VP Law, is a law office engaged in the general practice of law. Its principal office is conveniently located at the heart of the University Belt at Villasis Law Center, VLC, Unit 911 CKKFI Building P. Paredes Street, Sampaloc, Manila. VP Law was organized in 2015 by attorney Christian G. Villasis and continues to expand to date. From the start, VP Law has maintained a varied and prestigious client base and continues to be recognized as one of the leading law firms in the country. VP Law has a diversified general law practice as the firm handles all aspects of corporate, commercial and business transactions, protection and enforcement of intellectual property rights and data privacy rights, collection, civil and criminal litigation, admiralty and maritime practice, labor management relations, election, administrative and local government cases, real estate transactions, land titles, deeds and conveyances, foreclosure of mortgages, writ of possession, replevin, bought laws, business organizations and corporate regulatory compliance and taxation, among others. In addition, the firm offers contract drafting, review, and negotiation, legal research and consultation, as well as other legal assistance appurtenant thereto. At present, the firm's increasing number of lawyers is capable of handling various legal matters and cases and is able and willing to cater to clients' concerns with utmost professionalism and zeal. Apart from experienced VP law lawyers, its legal team includes highly competent paralegals and professional legal staff who are constantly inclined to assist the lawyers, thereby ensuring efficient and cost-effective service to its clients. VP Law aims to provide its clients with quality legal representation anchored on the ethics of hard work, commitment and responsiveness to clients' needs. This vision has been the moving force in the firm's growth into a first-rate, full-service law firm.
Good day to our dear attendees from different parts of the country. I pray that you're all in great state of health. This free webinar is streaming live via the Villasis Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section #VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the virtual law companion of Villasis Law Center. Allow me to share to you this good news. The virtual law companion is the newest innovation of Villasis Law Center, which aims to provide an easy, convenient, and quality bar review experience. The virtual law companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 through any web browser using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from any mobile device. Please visit our website at www.villasislawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team will be with you to assist you should you need more information about our program. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual claps and welcome our lecturer today. Again, this free webinar is brought to you by our virtual law companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Our lecturer is an authority in criminal law and special penal laws. He has obtained his Juris Doctor and Master of Laws degrees from San Sebastian College Recoletos, Manila. He teaches criminal law and special penal laws at San Sebastian College Recoletos, Adamson University, New Era University, and Thomas Claudio Memorial College. He is a seasoned bar reviewer and MCLE lecturer. He has authored books entitled Criminal Law Concepts and Jurisprudence, Book 1 and Book 2 of the Revised Penal Code, 2020 edition, Special Penal Laws Concepts and Jurisprudence, 2019 edition, Concepts and Jurisprudence on Comprehensive Dangerous Drugs Act of 2002, 2020 edition, and Compendium of Special Penal Laws, 2019 edition, all published by the Central Book Supply Incorporated. Currently, he serves as an assistant city prosecutor in Antipolo City. Let us all welcome Professor Freddy M. Noyara.
Good day, everyone. I am Professor Freddy M. Nohara, and welcome to this free online lecture. Okay, brought to you by Virtual Law Companion of Villasis Law Center. Prepare for the bar examinations at any time, anywhere, and from any mobile device. Check out the VLC website at www.villasislawcenter.com for more details and particulars. Optimize this learning opportunity. Like the VLC Facebook page or subscribe to VLC YouTube channel and share this live session. Host a watch party and tag your friends now, and together learn at the comfort of your homes. Before we start, please comment VLC if you can hear me clearly. Now we will proceed to the lecture proper. The topic today is critical areas or updates in criminal law 2, which consists of book 2 of the revised penal code. The study of criminal law now is not limited to the revised penal code only. Revised penal code was promulgated in 1930, became effective in 1932. So from its enactment up to the present time, there are several special penal laws that were enacted by our Congress. So the study now, for purposes of taking the bar examination or of studying criminal law in the College of Law, it is no longer the domain or the revised penal code that must be the focus of our study. Okay, as time has evolved, we have to take into account those special penal laws. Okay, okay. So if you are watching this online lecture, you are mistaken if your study will be only on the revised penal code. So the study must go hand in hand with special penal laws. I'm referring, for example, I'm referring, excuse me, to a special penal law, Republic Act 7610, or we call it the child abuse law. Okay, there are two areas in that special penal law that generally penalizes crimes committed against a minor. The victim is a minor, meaning to say the victim is below 18 or under 18 years old or under 18 years of age. Okay. If the victim is a minor, or even if she's not a minor, but he is a person who cannot protect himself or herself from any abuses committed by an adult, he is considered a minor. Okay? Okay. Generally, there are two types of penal acts that are provided under that law. Number one is the so-called sexual abuse or lascivious conduct under Section 5. And the other is the child abuse when there is under Section 10 of the law. Section 10 of RA 7610 concerns about the abuses committed, just like when there is injuries inflicted upon a minor. Okay, so that is covered by Section 10. But if you say, or if the act concerns sexual abuse or lascivious conduct committed against a minor, the governing section is Section 5. So that section, Section 5, that is the subject of our topic today. That must be considered together with crimes committed or the crime of rape and the crime of acts of lasciviousness under the revised penal code. So the revised penal code, this topic will focus on the crime of rape under Article 266-A and the crime of acts of lasciviousness under Article 336. On the other hand, we will touch on Section 5 of Revised Republic Act 7610, specifically the crime of sexual abuse or the crime of lascivious conduct. Okay, so we'll start. Okay, the outline of the lecture. First, we will identify the laws that penalize rape by sexual intercourse or sexual assault and sexual abuse or lascivious conduct. Second, we will identify the elements of those crimes: rape by sexual intercourse or sexual assault on one hand, and sexual abuse or lascivious conduct on the other hand. And what are the distinctions between these two crimes? Okay, what are the distinctions? And the rules as laid down by the Supreme Court in determining the proper crime if the victim is a minor. Okay. So let's go first with rape. Okay. You know, rape is used to be it was used to be under the title title 11 of the revised penal code, crimes against chastity. Rape was crime against chastity. Okay, but now, by virtue of Republic Act 8353, or the new anti-rape law, rape is now a crime against person, specifically under Title 8 of the revised penal code, crimes against person. So it is now under Article 266-A, 266-B, 266-C, up to 266-D. Okay. So what is the effect of the transfer of the rape from crimes against chastity to crimes against persons? Okay. The effect is the crime of rape is now a public crime, meaning to say, since it is a public crime, any person may initiate the complaint for rape. If it is a if it is a private crime, just like acts of lasciviousness, forcible abduction, concubinage, or adultery, no crime or complaint can be initiated except upon complaint filed by the offended party, by the victim. Now, since rape is now a crime against person, it is a public crime, anybody can initiate the complaint. Anybody can file complaint. Okay, that's the legal significance of the transfer of rape from crime against chastity to crimes against person. Okay, and another additional improvement or development introduced by RA 8353 is the additional kind of rape, which is rape by sexual assault. Okay? So, rape by sexual assault is different from rape by sexual intercourse. The old concept of rape used to be it is sexual intercourse. But now, there are two kinds of rape. Rape by sexual intercourse and rape by sexual assault. Okay, that is an innovation to our new law, to our revised penal code. Okay, so I have explained this a while ago, that crime of rape is now a crime against persons. Okay, we will take rape by sexual intercourse. Rape by sexual intercourse is a crime committed by a man against a woman. And the gravamen of this crime is sexual intercourse or carnal knowledge, to be more specific. So the central element is carnal knowledge. Hence, this crime can never be committed by a woman. Okay? Sexual intercourse or rape by sexual intercourse cannot be committed by a woman. Only committed by a man against a woman. So what is carnal knowledge? Since that is the central and the main element or the gravamen of this crime, carnal knowledge. Carnal knowledge has a technical meaning that this is the only crime that uses carnal knowledge as an element. Because carnal knowledge is not the same with sexual intercourse. Oh, why did you mention rape by sexual intercourse? Meaning, why is it that you brand it as a rape by sexual intercourse, since sexual intercourse is not necessary, is not the element, but carnal knowledge? So then the phrase sexual intercourse and the crime rape by sexual intercourse is just used just to label or to differentiate it from the other rape, which is rape by sexual assault. Okay, but rape by sexual intercourse is a misnomer. Okay, since sexual intercourse and carnal knowledge are different, because the element of rape is not sexual intercourse, but carnal knowledge. So what is carnal knowledge? Carnal knowledge is an act of a man having sexual bodily connections with a woman. O, walang sexual intercourse doon. That is the meaning of carnal knowledge. Act of a man having sexual bodily connections with a woman. So, meaning, if a man connects with a woman bodily, there is carnal knowledge. It does not pertain that there must be a sexual intercourse. The law does not say that. Okay. It is the basic element of the crime of rape, not ejaculation. So we are not concerned about any other element, but just carnal knowledge. So how is carnal knowledge committed? Okay, simple. The law requires that there must be a slightest penetration of the female genitalia. With what object? With the penis, with the tip of the penis of a man. When the tip of the penis of a man touches the external or the outer genitalia of a woman, there is consummated rape. So the moment the tip of the penis touches the outer genitalia, meaning the labia majora, there is consummated rape. So it is not required that the penis be inserted or the penis penetrate the vagina. That is not the requirement. Okay? Because what is required is slightest penetration of the female genitalia. Then the crime is committed. So that is carnal knowledge. It is not sexual intercourse. Because if you say sexual intercourse, that must be the penis, the male genitalia must penetrate the woman's vagina. So that is sexual intercourse. Okay. So in carnal knowledge, it does not require that the vagina be penetrated or the hymen be ruptured. Okay. So how do you distinguish carnal knowledge from sexual intercourse? Okay. Carnal knowledge is defined as the act of a man having sexual bodily connections with a woman. While in sexual intercourse, an essential ingredient thereof is the penetration of the female sexual organ. Okay, so that's the distinction between two. So the crime of rape is deemed consummated even when the man's penis merely enters the labia or the lips of the female organ. Because the mere touching of the external genitalia by a penis capable of consummating the sexual act, it is enough. That is enough. What is the nature of touching required? The nature of touching. Okay. The touching when applied to rape cases does not simply mean mere epidermal contact or stroking or grazing of organs. Yung nagbabanggaan lang yung mga organs nila. Okay. Or a slight brush or a scrape of the penis on the external layer of the victim's vagina or the mons pubis. The touching must be on the labia majora or the lips. No other part of the female genitalia should be touched, but except that portion, that lips. If the touching does not pertain to the lips, but to other parts, just for example, the mons pubis, the crime would only be attempted rape. Attempted rape. Okay? So, the touching must pertain to the labia majora, the lips of the woman's vagina. Okay. Okay. In some other decision of the Supreme Court expanded the meaning of touching. There is carnal knowledge when the tip of the erect penis of the offender touches the opening of the victim's vagina. Or when the victim felt slight pain on that part of her organ. So there is consummated rape even if the testimony of the victim is only about pain, that she felt pain on that portion, on that labia. That means to say, if that is the testimony of the victim, there is a consummated rape. Okay? So, in other words, if the victim's testimony proved that the accused penis had gone beyond the victim's mons pubis. What is big mons pubis? Mons pubis is that part of the genitalia, female genitalia, where pubic hair grows. Okay, that up near the abdomen. If the testimony of the victim proved that the penis gone beyond had gone beyond her mons pubis and had reached her labias, then there is consummated rape. Okay. If there is a finding by the doctor who examined the victim that the urethra of the victim, ano ba yung urethra? Urethra, it refers to that small opening where urine passes. The urine passes, that is urethra. If there is redness or erythema or redness at the urethra, then there is consummated rape. Take note, that is, the urethra is just a portion, just at the upper portion of the female genitalia where the urine passes through. Okay? So if there is redness, o hindi na siya labia, but near the labia, if there is redness of the urethra that demonstrates it was touched by the penis, there is consummated rape. Okay. So rape by sexual intercourse is easy to understand. What about rape by sexual assault? There are two ways to commit rape by sexual assault. First is by inserting the penis of the offender into another person's mouth or anal orifice. Take note of the word persons, not woman. Person. Okay. Or by inserting any instrument or object into the genital or anal orifice of another person. Okay. This kind of rape is also known as instrument or object rape, or gender-free rape, or homosexual rape. The gravamen of this crime is the insertion of the penis into another's mouth or anal orifice, or insertion of any instrument or object into another person's genital or anal orifice. Okay. Hence, the offender may be a man or a woman. Oh, take note of that. The offender may be a man or a woman, and the victim may be a man or a woman. In rape by sexual intercourse, the offender is a man, and the victim is a woman. Here, unisex, ika nga. The offender may be a man or a woman, or the victim may be a man or a woman. So, a lesbian can be an offender in this crime. If he inserted or inserts an object into the vagina of her partner against her will, so that is rape by sexual assault. A woman can now commit rape. What kind of object? So the object, it's either the penis must be inserted into another person's mouth or anal orifice sa puwet. Pag object, doon lang sa only to the vagina or anal orifice. So what are the examples of object we have? This is by virtue of Supreme Court decisions. And several Supreme Court decisions, the object is classified as either as a lit cigarette stick, nasindi ang sigarilyo, or a tongue, that is an object, or a finger, or any other solid object. Ito malala, 2019 ruling, a welding rod. Welding rod, recent jurisprudence, inserted into a girl's vagina, it is an object according to the Supreme Court. Buti hindi siya lighted welding rod. Okay? A finger or a tongue. Okay. It is required that the victim did not identify what kind of object was inserted. That is no longer required. As long as he can testify, that the victim can testify that there was an object, a hard object that was inserted or introduced into her vagina or into her anus. Okay. The object, as in the Supreme Court decisions I mentioned, would only classify this a tongue as an object, a finger, or any solid. But Justice Martires and Justice Marviglionen maintain a separate opinion regarding object. According to them, a finger is not an object for purposes of rape by sexual assault. If a finger is inserted into a woman's vagina, according to Justice Martires and Justice Lionen, the crime committed is not rape by sexual assault, but rape by sexual intercourse. Because finger is neither an object nor an instrument. It is a part of the human body. So if it is inserted, assuming a forefinger or a middle finger is inserted into a woman's vagina, the crime is not rape by sexual assault, but rape by sexual intercourse. Because if the offender who is a senior citizen can no longer perform sexual intercourse, he may do it by means of his finger. So the purpose, the objective is the same, to satisfy his lust, but not by his penis, but by his finger. But that's why Justice Martires and Justice Marviglionen maintain that finger is not an object nor an instrument. Okay, but that is their opinion only. The majority opinion is finger is an object. So if you will be asked in the bar exam, just answer the way the Supreme Court, the majority opinion of the Supreme Court had ruled on the matter. But since Justice Lionen, who is the bar examination chairman, in the next year's bar exam, if this is asked, you answer the view of Justice Lionen. The examiner will give you credit for that. Okay, what about oral sex? Cunnilingus or oral sex or fellatio. If the oral sex, it involves the use of, among other, a tongue. So cunnilingus or oral sex is a rape by sexual assault, not acts of lasciviousness. Take note of that. Okay. What about anus? Slightest penetration of anus of a male person, assuming the offender is a homosexual. That is consummated rape by sexual assault, because anus is compared with a woman's vagina. So slightest penetration or touching of the anus is rape, consummated rape by sexual assault. Okay. So the degree of penetration is not important. So what are the distinctions between sexual intercourse and sexual assault? Here. In sexual intercourse, the offender is always a man. Sexual assault, the offender may be a man or a woman. And the victim in sexual intercourse is always a woman. And the offended party in rape by sexual assault, it could be a man or a woman. And rape by sexual intercourse is committed through penile penetration of the vagina. However, in sexual assault, just it is committed by inserting the penis into another person's mouth or anal orifice or instrument or object into vagina or anal orifice. And the penalty for rape by sexual intercourse is higher, which is reclusion perpetua, than rape by sexual assault, which is prescription mayor. So those are the distinctions. Okay. The elements of rape by sexual assault are different from rape by sexual intercourse. So you cannot use the variance doctrine. These two crimes are different. If one is charged with rape by sexual intercourse, he cannot be convicted with rape by sexual assault because the variance doctrine is not applicable. Why? Because the elements of these two crimes are different. Okay, so you don't have to apply the variance doctrine under the criminal procedure. These two crimes can be committed in one occasion, in one incident. Rape by sexual assault and rape by sexual intercourse can be committed in one incident. Oh, assuming the offender forced the victim to swallow, or the offender forcibly inserts his penis into the victim's mouth. And later on, he inserts his penis in her vagina. So there are two crimes committed. You cannot say that the first incident is just a preparatory act for the preparatory act for the sexual intercourse. No, those acts constitute distinct and separate crimes. Okay, so the crime can be rape by sexual intercourse and rape by sexual assault. Now we go to RA 7610. Just in brief, this law, the child abuse law, was passed in 1992. Medyo matagal na. The purpose of this is to implement the National Comprehensive Program for the protection of the most vulnerable members of the population, and that is the Filipino children. This is pursuant to our Constitution, the constitutional mandate that the state should defend the right of the children against all forms of neglect, abuse, cruelty, exploitation, and other conditions which are prejudicial to their development. Okay, so that is the primordial objective of the law, to advance the state policy of affording special protection to children from all forms of abuse, neglect, cruelty, exploitation, and discrimination. Okay, so the main focus of our discussion is Section 5. This is the verbatim. This is the provision of Section 5B. Section 5B. From this provision, you can determine that a child is exploited in prostitution. Okay? There is the offender commits sexual intercourse or lascivious conduct with a child exploited in prostitution or subject to other sexual abuse. Okay? So, two instances or two occasions. The child or the minor is exploited in child prostitution. So when there is prostitution, there is payment of money or consideration, okay, in exchange for sexual favor, sexual intercourse. Or if there is no prostitution, there is no consideration or remuneration. There is other sexual abuse, and this is the common case, subject to other sexual abuse. We will discuss that later. Okay. Then the second proviso of this section, take note of this, please. If the victim is under 12 years of age, or 10 or 11 years old, if there is sexual intercourse committed against an 11-year-old girl, the offender is no longer penalized by sexual abuse or lascivious conduct under Section 5. But this law considers the sexual intercourse by the offender with an 11-year-old girl, for example, is no longer covered by this law. But it is covered by dati, before 335, rape under crimes against society. But now, it is now covered by 266-A, yung rape. Yung tinatawag, we call it statutory rape. Statutory rape. So, even if the victim consented, if the victim is under 11 years of age, that is automatic rape, statutory rape. Okay. So, that is the variation. What about if there is no sexual intercourse, assuming it is only touching of the sensitive part, or kunyari, touching of the breast? Is that covered by Section 5 and the victim is only 11 years old? No. According to this law, 5B, the same is covered by the provision of Article 336. That is acts of lasciviousness. Okay. Take note of this, please. Okay. This is our premise. Because in the subsequent discussion, baka malito kayo, because we have so many variations introduced by the leading case, People versus Kawili and People versus Tulagan. People versus Kawili decided in 2017 and People versus Tulagan decided in 2019. Okay. Let me go first with the elements of sexual abuse. Sexual abuse. Pag sinabing sexual abuse, that is a crime committed against a minor. Okay. And that is governed by Republic Act 7610. Okay. The elements of sexual abuse or lascivious, ang lascivious conduct, there is no sexual intercourse. Touching lang siya. There is a definition for that. These are the common elements. The accused commits the act of sexual intercourse, yeah, take note, sexual intercourse or lascivious conduct. So magkaiba sila. Okay? The crime would be different depending on the manner of committing it. If there is sexual intercourse, that is sexual abuse. If there is no sexual intercourse but merely touching, that is lascivious conduct. Magkaiba yan. And the second element is the victim is a child, exploited and in prostitution. That's one. Or other sexual abuse. That's two. Different scenarios. And the third element is the child is below 18 years of age. Okay. Let's go with the first element. What is sexual abuse? Sexual abuse includes the employment, use, persuasion, inducement, enticement, or coercion of a child to engage in or assist another person to engage in sexual intercourse or lascivious conduct of the molestation, prostitution, or incest with children. What is lascivious conduct? Lascivious conduct means intentional touching either directly or through clothing. Take note of the parts of the human body that need to be touched in order to constitute lascivious conduct. Genitalia, anus, groin, breast, inner thigh or buttocks. That's one. That's touching. So if the touching is made on other parts of the human body that is not included in the enumeration, that is not lascivious conduct. So if the touching is made on the head, buttock, or sa buttock, that is not lascivious conduct. If the touching is made on the shoulder, on the arm, that is not lascivious conduct. It should be on the genitalia, anus, groin, breast, inner thigh. Pag outer thigh, no. Or buttocks. That's another lascivious conduct. That's the first form of lascivious conduct, because there are two. And the second form of lascivious conduct is the introduction of what? Okay? The introduction of any object into the genitalia, anus, or mouth of any person, whether same or opposite sex. And the intent to abuse, humiliate, harass, or degrade, or arouse, or gratify the sexual desire of any person, of bestiality, of masturbation, lascivious exhibition of the genitals or pubic area of the person. So you are reminded that the second classification of lascivious conduct partakes the nature of rape by sexual assault. The only difference is, here the victim is a minor. If that is a rape by sexual assault, then the victim is more than 18, adult, hindi na siya minor. Okay? So that's the difference. Okay? So lascivious conduct means there are two meanings: touching and the introduction of an object. Okay. Now, this is important. Second element. The child is exploited in prostitution, or he is subjected to other sexual abuse. Now, there is a child is deemed exploited in prostitution when the child indulges in sexual intercourse or lascivious conduct for money, for profit, or any other consideration. That's prostitution. But if the mode resorted to by the offender is not through by money or profit or any other consideration, but there is coercion or influence by an adult, that is under the meaning of other sexual abuse. So, ang second element can be committed either by prostitution or other sexual abuse. I hope that is understood. Kaya I am explaining this in a more extensive manner so that you can understand, because this is difficult to understand. Even lawyers, even full-fledged lawyer, can sometimes can have a hard time understanding this concept. So when a child indulges in sexual intercourse or lascivious conduct due to the coercion or influence of any adult, the child is deemed to be exploited in prostitution or other sexual abuse. Oh, yan po. That's the meaning of it. Child prostitution or other sexual abuse. So the second element requires evidence to prove that the minor is either exploited in child prostitution or subjected to other sexual abuse. And secondly, he is a child as defined by the law, Republic Act 76. Okay. The phrase other sexual abuse covers not only child who is abused for profit, but if there is coercion or intimidation committed by the offender or by the adult. Okay. And the Supreme Court has expanded the coverage of coercion or influence. It also includes some other form of compulsion, which is equivalent to intimidation that subdues the free exercise of the victim's free will. It also, it may involve the element of influence that is which manifest in a variety of forms, or the employment, or the use, or the persuasion, or the inducement, or the enticement or coercion of a child to engage in or assist another person to engage in sexual intercourse or lascivious conduct. So the words coercion and influence can be explained in this wise. The law does not provide for definition. It is only by virtue of the jurisprudence, the leading case of which is the case of Quimbel versus People. The word coercion means the improper use of power to compel another to submit to the wishes of one who wills it. The Supreme Court borrowed Black's Law Dictionary because the law does not define what is the meaning of coercion. On the other hand, the term influence means the improper use of power or trust in any way that deprives a person of free will and substitutes another's objective. Okay? In lascivious conduct, under the coercion or influence of an adult, there must be some form of compulsion, which is equivalent to intimidation. In the case of Quimbel versus People, the Supreme Court said that coercion and influence are broader in scope than force and intimidation. Saan ba nakikita si force and intimidation? You can these words, force and intimidations, are found in the crime of rape under Article 266. The first mode of committing rape is by force or intimidation. Okay? According to the Supreme Court, coercion and influence are broader, mas malaki in meaning than force or intimidation. So coercion means compulsion or force. So under the word coercion, you can find force. And influence is defined as persuasion carried to the point of overpowering the will of the person. So these are the distinctions between coercion and influence on one hand, and force and intimidation on the other hand. This is the case. This is the case of Quimbel versus People. The third element, the child is below 18 years of age. How do you prove the age of the child? You can prove it by his birth certificate, the original or certified true copy of his birth certificate. In its absence, the law allows the presentation of secondary evidence, just like baptismal certificate or school or scholastic records or academic records. In the absence of those, the prosecution can prove the age of the child by a testimony of the victim's mother or any member of his family, either by affinity or consanguinity. So that's how you prove the age of the child. Okay, the problem is, if the victim is 12 years or older, the offender should be charged with either sexual abuse or rape under 266A. That's why I said this is the problematic area, because you can charge either rape under 266-A or sexual abuse under Section 5 of RA 76. But the question is, the big question mark is, when do you apply? When do you charge rape, or when do you charge sexual abuse under Republic Act 7610? The Supreme Court, in a series of cases decided by it, had a hard time deciphering or determining whether the person, the offender, committed rape or sexual abuse. I will cite to you those pertinent or relevant Supreme Court cases. Let's start with People versus Abay. Okay. In Abay, that is a 209 decision. The offended party was 13 years old at the time that she was raped. The information contained all the elements of rape and sexual abuse. So the prosecutor was also at a loss whether to charge the rape, to charge the crime of rape, or to charge the crime of sexual abuse, because he included all the elements of rape and the elements of sexual abuse. But the prosecution evidence focused only on the fact that the accused sexually violated the victim through force and intimidation by threatening her with a bladed instrument, enforcing her to submit to this bestial design. The prosecution here in Abay only proved force in intimidation. He disregarded or he ignored the elements of sexual abuse. So notably, the prosecution did not discuss the broader scope of influence or coercion. That's why the offender was convicted with rape. Correct. Now comes Pangilinan case in 2011. The Supreme Court was faced with the same problem because all elements of rape and all elements of sexual abuse were present, just like what happened in Abay. It was ruled that the accused can be charged with either rape or sexual abuse and be convicted therefore. However, in this Pangilinan case, the prosecution, it was observed that the prosecution evidence proved that the accused had carnal knowledge with the victim through force and intimidation by threatening her with a samurai samurai sword. The samurai sword was used by the offender in threatening the victim. So the trial court convicted the accused with the crime of rape. The influence or coercion, the element of influence or coercion for sexual abuse was not discussed, was not touched by the prosecution. So the crime was rape. Now, in 2017, the Supreme Court rendered People versus Tubilio. Now, the Supreme Court introduced the doctrine of focus of evidence approach. Nalito na sabi ng Supreme Court, let's settle this. We should lay the guidelines. In People versus Abay and People versus Pangilinan, it is required that the trial court must examine the evidence of the prosecution, whether it focuses on the force or intimidation employed by the offender or on the broader concept of coercion or influence. If the prosecution proves that the offender used force or intimidation, then convict the accused with rape. If the prosecution proves that the offender exercised coercion or influence, then convict the accused with sexual abuse under 7610. Kaya nga, focus of evidence approach. Meaning to say, it is dependent upon the prosecution's evidence. Okay? So that's People versus Tubilio. But the story does not end there. Because in another case, People versus Ejercito in 2018, this involves the accused using a gun and threatening to kill the victim. And he raped the victim. Afterwards, he left. The Supreme Court holds that in instances where an accused is charged and eventually convicted of having sexual intercourse with a minor, the provisions of rape under RA 8353 or Article 266-A of the Revised Penal Code should prevail. Okay. Should prevail. So the preference now is rape. Okay? Why? The focus of evidence approach as used in Tubilio was abandoned by the Supreme Court. Short-lived lang siya. Because ang Tubillo is 2017, si Ejercito 2018. Wala pang isang taon, the Supreme Court abandoned the doctrine. Let's stick to rape. The accused must be convicted with rape. Okay. There's no problem if the victim is 12 years old. Either force or intimidation or coercion or influence, that doesn't matter. That doesn't matter at all. Because any sexual intercourse committed by the accused with a victim who is below 12 years old is considered statutory rape. Rape yan. Settled yan. The express provision of the law in Article 266-A and Section 5B of Republic Act 7610, that's rape. Statutory rape. So these are the distinctions between rape by sexual intercourse and sexual abuse under 7610. Okay? Rape is committed by force or intimidation or deprivation of reason or the victim was unconscious. Sexual abuse by means of coercion or influence. Consent exonerates the accused from rape charge. Meaning, if the victim gave her consent, there is no criminal liability. But in sexual abuse, the consent is immaterial in sexual abuse, where the victim is a minor. That's why the sweetheart defense is acceptable in rape, but not so in sexual abuse. But that was before Tulagan case. Okay, I should clarify this, that the sweetheart defense is unacceptable in, that was before Tulagan case. Tulagan case is March 2019. Now, I mentioned Tulagan case. People versus Salvador Tulagan decided in March of 2019, never been given in the bar examination. If you are taking the bar this year or next year, take note of this case, People versus Tulagan. Because many jurisprudence were clarified by the Supreme Court in this case of People versus Tulagan. These are the rules to be observed when you are in a quandary as to what proper crime should be charged. It's either rape or sexual abuse. These are your guide. These are your parameters or standards to be observed. First, if sexual intercourse is committed with an offended party who is a child and less than 12, or if she is demented, whether she is exploited in prostitution or subjected to other sexual abuse, the proper crime is always statutory rape. The only element that we will determine is whether there was sexual intercourse and the age of the victim, who is below or under 12 years of age. Second, when the offended party is 12 years old or below 18, and the charge against the accused is carnal knowledge through force, threat, or intimidation, then the proper crime is rape. Okay. However, in case of a sexual intercourse with a child who is 12 years old or below 18, who is deemed exploited in prostitution or other sexual abuse, and the victim indulges in sexual intercourse because of money, profit, or any other consideration, or due to coercion or influence of any adult, syndicate, or group, then the crime is not rape, but sexual abuse under RA 76. Only now, di ba? The guidelines are clear on this respect. I will give you some scenario before we proceed to next topic, acts of lasciviousness and lascivious conduct, because the other topic is about sexual abuse and rape. Now we go to acts of lasciviousness on one hand and the crime of lascivious conduct on the other hand. Magkaiba sila, ha? Acts of lasciviousness is governed by Article 336. Lascivious conduct is governed by Section 5B of 7610. Scenario 1. The offender touched the breast of the victim who is 14 years old. What crime was committed? Scenario number 2. The offender touched the breast of the victim who is below or under 11 years of age. What crime was committed? Scenario number 3. The offender inserted his finger into the vagina of the victim who is 14 years of age. What crime was committed? Scenario number 4. The offender inserted his finger into the vagina of the victim who is 11 years of age. What crime was committed? Mamaya, para-parehas ang sagot nyo. But the answers are different. So, listen to this. 7610 or Republic Act 7610 requires lascivious conduct. On the other hand, RPC or Revised Penal Code punishes acts of lasciviousness under Article 336 and sexual assault under 266-A. So there are two different acts involving acts of lasciviousness. One is under 336 and the other is under 266-A. Now we go to lascivious conduct. Lascivious conduct is used in violation of Republic Act 7610. Do not use it for violation of the Revised Penal Code. Although I made it clear in one of the previous slides, the meaning of lascivious conduct, I will reiterate just for purposes of clarity. There are two, in lascivious conduct, there are two components. The first is touching, intentional touching, either directly, indirectly, skin to skin. Yung clothing, through clothing is when touching is made over the dress or the shorts, or when there is the victim is wearing his or her clothing, okay, of the genitalia, anus, groin, breast, inner thigh, or buttocks. That's clear. Those are the only parts of the body that need to be touched in order to have lascivious conduct. Lascivious conduct is also committed when there is introduction of any object into the genitalia, anus, or mouth of any person. So para siyang sexual assault din. Para siyang rape by sexual assault, because in rape by sexual assault, it also involves the same manner. When it is a penis, it is inserted into another person's mouth or anal orifice. When if it is an object, just like a finger, it is inserted into the genitalia or anal orifice. Okay, so those are the two components of lascivious conduct. Okay, huwag kayong malilito ha. We are only after dealing with 7610. On the other hand, what is acts of lasciviousness under Article 336? Article 336 states that there is acts of lasciviousness, or acts of lasciviousness is committed by any person who shall commit any act of lasciviousness or lewdness upon other persons of either sex, under the circumstances mentioned in Article 335. So the acts of lasciviousness under Article 336 is only limited to acts which are considered lewd. So what are acts that are considered lewd? In the case of employer versus people, that is the leading case in acts of lasciviousness, the Supreme Court defined lewd as something indecent or obscene, or it is characterized by or intended to excite crude sexual desire. So that is the meaning of acts of lasciviousness. So the meaning is quite broad. Okay. However, before the enactment of RA 8353 or the new anti-rape law, the insertion or introduction of an object into another's genitalia or anus can be considered as acts of lasciviousness. That was before. But when the act of introduction of an object into another's genitalia or anus was specifically penalized as rape by sexual assault under Republic Act 8353. That act is taken out of operation of Article 336, meaning that is no longer considered an act of lasciviousness. That's why the definition of lewd or acts of lasciviousness does not cover acts of introduction of any object into the genitalia, anus, or mouth. Why? Because that is already covered by the Revised Penal Code in Article 266-8 as sexual assault. Okay? So I hope you can follow. If you cannot follow, just review it, this tape, this presentation, just have a rerun, replay, so that you can understand. I know this is difficult to understand, but I'm trying my best to make the presentation or explanation more simple. Now, sexual assault is a crime under 8353 or Article 266-8. That is a crime committed by inserting any instrument or object, yung sinabi ko na kanina, into the genital or anal orifice of another person. Now, the act of sexual assault is not covered by the crime of acts of lasciviousness. So the acts of lasciviousness, the crime of acts of lasciviousness under Article 336 would only pertain to touching. But because if the act includes the introduction or insertion of a foreign object into the woman's genitalia or anus, that is no longer acts of lasciviousness, but rape by sexual assault. I hope you follow. Okay. So, hence, if the act involves sexual assault, you do not apply Article 336, but apply 266, Article 266-8 of the Revised Penal Code. Now, we go to a situation where the victim is a minor. Okay. The rules as prescribed by the Supreme Court in 2017 in People versus Kawile, August 2017, are as follows. The age of the victim is taken into consideration in designating or charging the proper offense and in determining the imposable penalty. If the victim is under 12 years of age, the crime is acts of lasciviousness under Article 336 because that is a mandate made by Section 5B of RA 7610. You read Section 5B, the second sentence there. If the victim is less than 12 years old, the governing law is 336. What is 336? Acts of lasciviousness under People versus Community. Second, if the victim is exactly 12 years of age, or more than 12, but below 18, the crime is lascivious conduct under Section 5B. Hindi siya acts of lasciviousness under 336. Why? Because we have a law, the Public Act 7610. Okay? 7610 would not apply if the victim is below or under 12 years of age. But Kawile has a defect. The Supreme Court did not anticipate that a sexual assault, or if an act involving insertion or introduction of an object into the genitalia or anus, it is not captured by acts of lasciviousness. Because under Section 5, the law, Section 5B of RA 7610, only mentions acts of lasciviousness. 336. However, Republic 7610 is overtaken by another law, which is Republic Act 8353, yung pinanggalingan ni Article 266-8, which is more recent than 7610. Luma si 7610, bago-bago si 8353. 8353. Under RA 8353, the concept of acts of lasciviousness has been expanded, meaning not expanded, but limited. I'm sorry for that. The concept of acts of lasciviousness has been limited only to acts of touching. Because if the act involves is introduction of an object or insertion of an object, it is not covered by 336, but RA 8353 as sexual assault. What about if the victim is below 12 years of age? And the crime and the act involved is introduction of an object. Sa kantong word, yung kunyari, fininger siya. Oh, pardon my word, because that is the best word that I can use to describe a scenario. What about if the offender fingers a victim who is 11 years old? Is that acts of lasciviousness pursuant to Section 5B of RA 7610? No, that is not covered. If you follow People versus Kawili, according to the Supreme Court, that is acts of lasciviousness. The Supreme Court did not anticipate that. That's why in People versus Tulagan, March 2019, this impasse has been remedied. According to Justice Peralta, or I'm not sure if it is Justice Peralta, the opponent of that Tulagan case, the Supreme Court clarified in quotation mark the rule, the Kawili case. According to the Supreme Court in Tulagan case, these are the rules to be followed. Okay, number one, if the acts constituting sexual assault, yun yung fingering or introduction of foreign object, are committed against a victim under 12 years of age, the offense now is not acts of lasciviousness pursuant to this Kawili, dito, Kawili, but sexual assault. See, under Article 266-A, in relation to Section 5B, RA 7610. Nilagay lang in relation because the proper crime is sexual assault, but the penalty is that penalty prescribed by Section 5B, which is reclusion temporal. Because the crime of sexual assault under 266-A is only prisión mayor. So the name of the crime is sexual assault in relation to Section 5B, because the law puts in relation because the penalty to be imposed is pursuant to Section 5B. That is reclusion temporal. Okay. Now, if the victim is 12 years old and under 18 years old, 14 years old yung victim, fininger siya, that is crime of lascivious conduct, not sexual assault anymore. Okay? Pag 12 years less than 18, fininger siya, lascivious conduct. Ang kaso. Sir, bakit kanina sexual assault? Because sabi ng Section 5B, pag ang victim is less than 12 years, acts of lasciviousness, sabi ng Section 5B, RA 7610. But now, hindi na siya covered ng acts of lasciviousness, but covered na siya ng Article 266-A, which is sexual assault. So the crime is sexual assault if below 12. Pag below, more than 12, less than 18, kahit na fininger siya, hindi siya sexual assault. Lascivious conduct pa rin. Lascivious conduct. So other forms of acts of lasciviousness, such as touching of delicate parts or the kissing of a young girl with malice, are still acts of lasciviousness under 336 in relation to 7610 or lascivious conduct under Section 5 of RA 7610. So, ang sexual assault can be committed if the victim is below 12 years of age or more than 18. o adult na. If, kunyari, isang dalaga, the offender inserted his finger into the genitalia of a 19-year-old woman, the crime is not lascivious conduct because he's no longer covered by 7610. But Article 266A, rape by sexual assault. Eh, bakit si below 12 years of age, sexual assault? Because the law itself, Section 5B, tells us to use Article 336, that is acts of lasciviousness. But Article 336 is no longer does not cover anymore the act of introduction of a foreign object, but it is covered by 266-A pursuant to Republic Act 8353. Kaya, ganun. I hope it is, you can, okay. I hope you understand what I'm talking about here. That's why, if you do not understand the first time you hear, just review the tape. And until such time that you can now understand. So in answer to the scenario number 1, okay. In scenario number 1, the offender touched the breast of the victim who is 14 years of age. What crime was committed? The answer is lascivious conduct. Why? Because that is covered by Section 5B of 7610. Scenario number 2. The offender touched the breast of the victim who is 11 years of age. What crime was committed? Section 5B, but Section 5B tells us to apply Article 336, which is acts of lasciviousness, in relation to Section 5. Ayan. The proper crime is acts of lasciviousness in relation to Section 5B. Okay. Scenario number 3. If the offender inserted his finger into the vagina of a victim who is 14 years of age, what crime was committed? Lascivious conduct. Because covered siya ng 7610. The act of touching a breast is within the meaning of lascivious conduct. Yung kanina, in touching, either directly or through clothing, of genitalia, breast, buttock, anus, groin, and their thigh. Yeah. So that is lascivious conduct. In scenario number 4, the offender inserted his finger into the vagina of a victim who is 11 years of age. The crime is committed sexual assault. We go back to 266-A because Section 5B of 7610 tells us to prosecute the offender with dati 336 or acts of lasciviousness, but now nagiging Article 266-A na of the Revised Penal Code pursuant to Republic Act 8353. I hope that is clear. My lecture on this critical area, especially on the prosecution of rape vis-a-vis sexual abuse or lascivious conduct under Republic Act 7610 is clear. You know, personally, as a public prosecutor, as a prosecutor by profession, we usually encounter this kind of cases. So it's very difficult to designate the proper crime if you do not know the rudiments or the basic concepts as laid down by the Supreme Court in the case of People versus Kawili and People versus Tulagan, using the other case, Quimble versus People. Okay, it's really difficult. I should tell you, I am in the forefront of prosecuting 7610, Republic Act 7610, and the rape on the other hand. So if you have any question or comment, just register your comment VLC at the online. We will be able to see it, and if possible, we will answer your question. I hope it is understood, and I believe I delivered and conveyed to you the meaning of these concepts. Thank you and good day.
The law firm of Villasis and Partners, VP Law, is a law office engaged in the general practice of law. Its principal office is conveniently located at the heart of the University Belt at Villasis Law Center, VLC, Unit 911 CKKFI Building P. Paredes Street, Sampala, Manila. VP Law was organized in 2015 by attorney Christian G. Villasis and continues to expand to date. From the start, VP Law has maintained a varied and prestigious client base and continues to be recognized as one of the leading law firms in the country. VP Law has a diversified general law practice as the firm handles all aspects of corporate, commercial and business transactions, protection and enforcement of intellectual property rights and data privacy rights, collection, civil and criminal litigation, admiralty and maritime practice, labor management relations, election, administrative and local government cases, real estate transactions, land titles, deeds and conveyances, foreclosure of mortgages, writ of possession, replevin, bought laws, business organizations and corporate regulatory compliance and taxation, among others. In addition, the firm offers contract drafting, review, and negotiation, legal research and consultation, as well as other legal assistance pertinent thereto. At present, the firm's increasing number of lawyers is capable of handling various legal matters and cases and is able and willing to cater to clients' concerns with utmost professionalism and zeal. Apart from experienced VP Law lawyers, its legal team includes highly competent paralegals and professional legal staff who are constantly inclined to assist the lawyers, thereby ensuring efficient and cost-effective service to its clients. VP Law aims to provide its clients with quality legal representation anchored on the ethics of hard work, commitment and responsiveness to clients' needs. This vision has been the moving force in the firm's growth into a first-rate, full-service law firm.
you.